you. Just an interesting historical point. You mentioned the use of legal harassment methods against civil rights activists. And the New York Times versus Sullivan case, which rewrote libel law, was just such a case. It involved a political ad that a group of civil rights activists had taken out in the Times criticizing some local officials in Alabama. And I think it's ironic that today we have the New York Times take the editorial position that political ads, if they're sponsored by corporations, excluding, of course, media corporations like the New York Times Company, should not be protected by the First Amendment, and denouncing the Supreme Court for giving them protection. So forgive my little editorializing here, and I present Irwin Cotler.
The underlying thesis of my remarks is that one of the enduring lessons of the Holocaust and the genocides that followed in Srebrenica, in the Balkans, in Darfur, is that these genocides occurred not simply because of any machinery of death, but because of state-sanctioned incitement to genocide. As the Supreme Court of Canada put it in words that were affirmed afterward by the International Criminal Tribunals for former Yugoslavia and Rwanda, that the Holocaust did not begin in the gas chambers. It began, as the court put it, with words. And they added, these are the chilling facts of history, the catastrophic effects of racism. In other words, even in a constitutional democracy like Canada, with a broad constitutional protection for free speech, where the Supreme Court of Canada in the Switzerland and Ebling case said regarding freedom of speech that liberty in these matters is little less vital to man than breathing is to his physical existence. One of the more compelling statements regarding freedom of expression. Nonetheless, the court held in a series of principles and precedents that the willful promotion of hatred and contempt against an identifiable group in a public place composing a threat to the peace was not a constitutionally protected speech. I won't go into the reasons. I'm prepared to do so if I'm asked, but let me just make full disclosure in that regard. I appeared before the Supreme Court in those cases which upheld the constitutionality of anti-hate legislation. And I did so even though I otherwise appeared in many of the free speech cases in Canada, and even though I'm a broad exponent of freedom of speech. But as I learned a long time ago, while a student here in the States at Yale Law School, in the homes of the First Amendment, that there is no such thing as absolute free speech, that all democracies, all constitutional democracies, authorize certainly defined limitations on free speech. That, as the Supreme Court of Canada put it in Boherna in Illinois, which was cited in our own Supreme Court jurisprudence, and I quote because it's relevant to my remarks, sinister abuses of free speech can tear apart a society, brutalize its dominant elements, and persecute, even to extermination, its minority. But let me come to my basic point in that regard, that even if one were to argue against hate speech legislation, even if one were to take the position that all speech, however hateful, is permissible, even if one were to take the position against any legislation regulating hate speech, and that the only answer to hate speech is more speech, even if one were to take that position, though I might add parenthetically, and Doug Murray made this point better than I can, that just in the month of February, March alone, at 10 different universities, people who were espousing positions deemed friendly to Israel were shouted down in the name of freedom of speech, and then they took the podium to propagate hate in the name of freedom of speech. So you had this kind of a two-tiered use of lawfare in that regard. But even taking that position, as I say, that all hate speech is protected speech, that is utterly distinguishable. What takes place in a constitutional democracy like Canada and the United States, utterly distinguishable from state-sanctioned incitement to genocide in the genre of the Balkans, Srebrenica, Rwanda, Darfur, and the like. Which brings me now to the phenomenon that we are witnessing today, because all those other cases, all those other case studies have already occurred. What we are witnessing now is a new state-sanctioned incitement to genocide, whose epicenter is Ahmadinejad's Iran. And I use that term, or metaphor, to distinguish it from the people and publics of Iran who are otherwise the targets of mass domestic oppression. But what we're witnessing in Ahmadinejad's Iran is a toxic convergence of four distinct yet interrelated threats: the nuclear threat, the genocidal threat, the terrorist threat, and the rights-violating threat. Let there be no mistake about it. Iran is in standing violation of international law prohibitions against the development and production of nuclear weapons. Iran has already committed the crime of incitement to genocide prohibited under the Genocide Convention and the ICC Treaty. And I say this as someone who has prosecuted Rwandans and others for incitement to genocide. There's a critical mass of precursors of incitement to genocide in Ahmadinejad's Iran that is almost without parallel or precedent. This had led some 60 international law scholars to recently release a petition, international law scholars, human rights people, experts in genocide, to release a petition that is organized around two themes or parts. The first is the most comprehensive and authoritative evidence about this critical mass of fourfold threat to which I was referring. The second is a framework of remedies with respect to redressing this critical mass of threat, recommendations of 10 sets of generic sanctions regarding the critical mass of threat as a whole, and threat-specific legal remedies. And with this I move to a close. Take the case of state-sanctioned incitement to genocide. As I said, Iran has already committed the crime of incitement to genocide. Yet as we meet, not one state party to the Genocide Convention, not the United States, not Canada, not France, has undertaken the mandated legal remedies, what lawyers call jus cogens, overriding legal obligations in international law, to hold Ahmadinejad Iran to account. None of them has initiated a modest remedy to, for example, today, tomorrow, initiate an interstate complaint before the International Court of Justice against Iran, which is also a state party to the Genocide Convention, to simply refer this state-sanctioned incitement to genocide to the UN Security Council for deliberation, account sanctions, and the like. There have been a reference on the nuclear issue only, and while the nuclear threat is clear and compelling, to ignore or marginalize the state-sanctioned incitement to genocide is to effectively sanitize it and to effectively ignore our own legal obligations to combat it. And so we have a situation that a man like Ahmadinejad, and I would even include, I'm using that metaphorically because the Iranian leadership, who incite to genocide, who are complicit in the commission of terrorist acts, who violate and in standing violations of prohibitions regarding the development of nuclear weapons, and I can go on. Such people enjoy legal immunity when they should be before the docket of the accused. Ahmadinejad can come before the UN Human Rights Council, can come before the UN General Assembly, can travel internationally freely and the like. Look at the New York Times front page picture, another embraced by another leader, yet no liability whatsoever. And so I close by saying that at this point, in a situation where we have been witnessing the exploitation of the law for lawfare purposes, it's our responsibility to take back the juridical narrative, retake fidelity to the rule of law, and in doing so, to bring Ahmadinejad's Iran to justice.